Well, joining us now for more is Professor Alan Dershowitz, Professor Emeritus of the Harvard Law School, speaking to us from Martha's Vineyard in Massachusetts. And Professor Dershowitz, thanks for joining us. With some of these reports out there, I have to start by asking you, have you been approached or have had discussions about representing President Trump in a possible impeachment trial? And if your answer to that is either no comment or no, my second question would be, would you be willing to represent him?
Let me answer the first question with a categorical no, and the second question with I don't engage in hypothetical conversations. There won't be a trial. There's no room for lawyers here because the Congress is going to impeach him without any opportunity for lawyers to present any evidence, and the Senate will never have a trial because the earliest the trial could take place would be on 1 o'clock in the afternoon on January 20th. Which is when Donald Trump becomes a private citizen, and the jurisdiction of Congress doesn't intend to private citizens. If it did, if you could impeach and remove a private citizen in order to prevent him or her from running again for president, then you can impeach me. I'm eligible to run for president. I'm 82 years old, but that's over 35. I've never been convicted of a felony. I can run for president. And so under the absurd notion that's being put forward by some senators and pundits that you can try somebody after they leave the office of president, it would mean that 40 or 50 million people would be subject to impeachment and, quote, removal or application from office.
I'm going to give you a different set of circumstances there. We're hearing some reports that the House could vote on the impeachment. They could even write up the articles of impeachment. But as we saw even in the last impeachment hearing, Speaker Pelosi could withhold those and then present them only after he had left office.
That would be completely unconstitutional. It would be like indicting somebody, never intending to bring him to trial, giving him no opportunity to prove his innocence. You can't have an impeachment unless it's going to be followed by a trial. And the idea of sending a message, what the message would be, and the reason I'm so opposed to it, is the message would be, I want to quote what one of your persons quoted, limits to appropriate dissent. Well, there are no limits to appropriate dissent. Dissent is covered by the Constitution.
What about, but there is a difference between dissent and incitement. You do acknowledge that there is a difference in those two phrases.
Not only do I acknowledge it, I've been teaching it and writing about it since the 1960s, but incitement has a very particular definition which doesn't even come close to what happened last Wednesday. What happened last Wednesday falls clearly on the side of advocacy. The leading case is Brandenburg. It involved a Ku Klux Klan person who was yelling, send the Jews back, kill the Jews, kill blacks, send them back to Africa. Horrible, horrible stuff. And the United States Supreme Court, in a 9-0 unanimous decision, said that was protected speech under the Constitution. We have a jurisprudence of free speech, and people are now trying to trash that jurisprudence in an effort to 7 days.
I do want to ask you, Professor Dershowitz, you are talking about legal terms, but you could correct me if I'm wrong. Isn't impeachment as much a political process as it is a legal process? So you're giving legal definitions that may not apply in perhaps the context of an impeachment process or trial.
They do apply. They do apply. The Constitution sets out legal criteria for impeachment. It uses legal terms: bribery, treason, or other high crimes and misdemeanors. Those are all legal terms. You cannot impeach a president for a speech that is covered and protected by the First Amendment. If you could impeach virtually any president. Presidents have made incendiary speeches. Presidents have engaged in terrible, terrible conduct. Franklin Delano Roosevelt confined 110,000 Japanese Americans in camps. He closed the door to Jewish immigrants from the Holocaust. He did terrible things. Many presidents have done terrible things. But unless they committed treason, bribery, other high crimes and misdemeanors.
Well, high crimes,
those are legal terms, yeah.
High crimes and misdemeanors, though, correct me again if I'm wrong, there is not an exact definition in the Constitution about what constitutes a high crime. I would guess the argument here is that the president inciting a mob to this is the presentation, that would fall in their definition of high crimes and misdemeanors.
Well, then you can make anything a high crime and misdemeanor. The first time they impeached them on grounds of abuse of power. And I showed on the floor of the Senate that 44 American presidents have been accused of abuse of power. Many have been accused of obstruction of Congress. The debates in the Constitutional Convention made it clear that you need criminal type behavior. That was the accepted view all through the 19th century. But in recent years, some academics have tried to redefine the criteria for impeachment. Congressman Waters said, impeachment is anything Congress wants it to be. There is no law. That is totally lawless. Congress is not above the law. The Constitution constrains Congress. James Madison said, we don't want to have open-ended criteria for impeachment lest the president serve at the pleasure of Congress, the pleasure of the Senate.
Well,
that's what was rejected by the framers.
Well, Professor Dershowitz, let's look at the process, because you keep saying the Constitution decides this. Of course, the Constitution has to be interpreted either by the Congress or, I guess, in this case, the Supreme Court. So on the question of whether you could try a president who maybe has been indicted by the House before he leaves office, would that not, it's unprecedented. It's not actually spelled out if I'm in the Constitution. Would that not come to the Supreme Court? Would not that be a decision the Supreme Court would have to make?
It's spelled out in the Constitution. The Constitution says the president may be impeached for treason, bribery, high crimes, and misdemeanors and removed from office. It doesn't apply to somebody who's not in office. You cannot try a private citizen. You cannot try Barack Obama. You cannot try Bill Clinton. And you cannot try Mr. Donald Trump after January 20th of this year. That's clear in the Constitution.
But what if
anybody is selling you a bill of goods, and a partisan bill of goods, to be sure?
Well, let's look at the possible process. If the U.S. Congress would make that decision and would pass that, again, is that not an issue that would then come up to the Supreme Court, and they would have to make a decision on, I would presume, on whether that's allowed or not?
The Supreme Court has so far said that they don't have jurisdiction over impeachment. There have been two justices, White and Souter, who dissented. And so we don't know whether the Supreme Court would take the case if Congress clearly went beyond its authority. If Congress tried to impeach me, and under what Senator Rubio has said, Congress could impeach me because I'm eligible to run for president, then the Supreme Court would probably take the case. But if Congress were to impeach the president while he was a sitting president and then try him after he were sitting president, probably it would be null and void, but there'd be no way of challenging that necessarily in the Supreme Court. Not everything that's unconstitutional is subject to review by the Supreme Court. But remember that senators are required to take an oath of office. I'll give you another provision of the Constitution. It says when the president is impeached, the Chief Justice shall preside at the trial. So would the Chief Justice preside if the president were impeached, but the trial occurred after he was president? The Constitution says the president, if he's on trial, the Chief Justice presides. The Constitution seems to clearly imply that the only kind you can have impeachment is for a sitting president, not for a.
But as you said that
they're prepared to stretch the Constitution and break it in order to get Trump. The reason I'm so interested in this case is what happened on Wednesday was terrible and awful and unforgivable, and the people should be prosecuted. But that was a one-day event. What I don't want to see happen is the Constitution destroyed, the First Amendment destroyed, the criteria for impeachment destroyed, the 25th Amendment destroyed, due process destroyed, just in the interest of getting rid of somebody who has 9 more days to serve in office. That makes absolutely no constitutional sense, and I will fight it to the hilt. I disagree with what the president said. I disagree with what he did. But as Voltaire said, I oppose what you said, but I will defend to the death your right to say it. President Trump.
Professor Dershowitz, in your own words, you said the Constitution seems to imply that a president can't be tried once he's out of office. It does not specifically say that. So that does leave open the possibility, the interpretation. You
can. So if you interpret it that way, then you interpret it to allow it to impeach me. And if you think they can impeach me, fine, that's a consistent interpretation of the Constitution. But it's absurd. The framers would laugh at you. No, let me be very clear. The Constitution could not be clearer that you cannot impeach and remove somebody who is not an office holder of the United States. There simply is no jurisdiction. There's no power. The impeachment process applies to sitting presidents, vice presidents, and other officials of the government.
I want to go back.
Applies to
Right.
Listen.
I want to go back to your issue of the First Amendment. First Amendment, of course, does not cover incitement, yelling fire in a crowded theater. Liz Cheney, for example, of the
It does cover yelling fire in a crowded theater. Let me be very clear. The Supreme Court decision in which that absurd analogy was given, I wrote a whole article about it, how stupid shouting fire in the theater is, because it's not words, it's like setting off an alarm. It was the case called Whitney and Shep. Those cases were overruled by the United States Supreme Court. So the analogy to shouting fire in a crowded theater no longer applies. The Supreme Court has reversed that decision. Shouting fire in the theater has been used to deny all kinds of speech. It's been used against union leaders. It's been used against civil rights workers. It's been used against suffragettes. It's one of the worst expressions ever to come out of the pen of Oliver Wendell Holmes, and it should never be used in serious debate. It makes no sense at all, and it has no application to a political speech in an open area where somebody is making an argument about whether the election was fair or not. I reject his arguments in the marketplace of ideas, but to analogize that to shouting fire in a crowded theater is preposterous, absurd, demeaning, and insulting. Why is it demeaning and insulting? Because when you shout fire, you don't ask anybody
Professor
to think about
Dershowitz,
it. Let me finish, please.
I'm afraid we're running out of time.
It's a message to the legs. And so when President Trump made his speech, some people agreed with it, some people disagreed with it.
We have 10 seconds before we go to break, Professor Dershowitz. I do want to thank you for coming on I-24 News. As you said, you haven't been approached to represent President Trump, but you said you would fight it. We'll see what happens. Thanks for joining us.